This is cause number 18-0661, Ramon versus Short. Counsel ready to proceed? Okay. Mr. Reed.
Good morning, Mr. Chief Justice, and may it please the court. Counsel, Alex Raitt with the ACLU of Montana on behalf of the plaintiff and appellant Augustine Ramon. With me today is Daniel Galindo with ACLU's National Immigrants' Rights Project. Montana is among numerous states grappling with the issue of whether there is state arrest authority for local law enforcement to hold individuals at the behest of federal immigration officials. And Montana should join every other state with a similar statutory scheme in holding that there is no such authority. Now, there are two separate but obviously related issues pending before the court today. I intend to briefly address the issues related to justiciability and mootness before turning it over to Mr. Galindo to argue the merits. And we would ask for 10 minutes of time for rebuttal. First, let me briefly turn to the issue of justiciability. Now, there is no doubt, and it's undisputed, that Mr. Ramon is no longer in the custody of Lincoln County. And that would make it difficult, if not impossible, for this court to order effective injunctive relief on his behalf. But the court should apply a mootness exception to this case. Courts have carved out these exceptions to the mootness doctrine for very similar sets of facts.
Now, counsel, before you actually get to mootness and the exceptions, I guess I have a question of whether the case happened. At what point did Mr. Ramon come up against the detention order, and was he prejudiced by the detention order? The county is arguing that he was never held pursuant to the detention order.
So the moment at which he was held pursuant to the detention order was the moment at which the bail bondsman attempted to post bond on his behalf and was informed that it would be futile. And if you look at the affidavits that were provided by the county in this situation, it's their policy and practice to comply with detainers. And this is exactly the issue that the district court addressed in its opinion, where it said that essentially Mr. Ramon is stuck between a rock and a hard place because, based on the county's reasoning, the case can never be ripe unless he posts bond. But at the moment that he posts bond, it will be moot because he would be transferred to federal custody within 48 hours.
The district court said about those allegations that they are untested facts and assumed, just for purposes of the legal arguments, that they were true, but said they had never been established. Do we have a proper record in this case?
We do have a proper record, and I actually believe that this case is teed up remarkably well for this court to reach the merits, Justice Rice. And the reason is that while the court had some quibbles about the submission of affidavits for the preliminary injunction hearing, at the end of the day, it reached the merits, and it reached the merits in a very clear way. And the underlying facts of this case, Your Honor, are undisputed. I mean, the fact that Mr. Ramon was held in Lincoln County, that there was a federal immigration detainer that was issued, and that the county essentially has a policy of holding an individual up to 48 hours beyond the time that they would otherwise be released.
Thank you.
So with regard to the issue of the application of exceptions to the mootness doctrine, these are exceptions that are narrowly circumscribed. They're well-grounded in legal and public policy considerations, and they are entirely within the discretion of this court to apply in order to reach the merits. The first exception that maps particularly well to the facts of this case is the public interest exception, an exception that has been adopted in 43 states and which was first recognized in Montana in the state ex rel Ronish case, which involved the placement of an underage juvenile into first grade. During the pendency of the appeal, the court determined that the case became moot, but nevertheless reached the merits because it said the matter is of great public interest and concern. So the rule itself is straightforward. It's a three-pronged test. First, do we have the existence of a question of public importance? Second, is there the desirability for an authoritative determination that would guide officials in the performance of their duties? And finally, is the question likely to recur? So on that first prong is, do we have a question of public importance? We have a question of public importance because of the proliferation of detainers that have been issued over the course of the last decade by Department of Homeland Security. These are detainers that are not just requesting notice that an individual would be released, but also that that person be held for an additional 48 hours beyond the time that they would otherwise be released. It's an issue of public importance as demonstrated by the numerous other states that have grappled with the very same issues with identical procedural postures, whereby those issues were technically moot by the time the appellate court had the opportunity to review. It's an issue of public importance as demonstrated by the numerous media coverage across the state, recognizing or standing in the shoes of the body politic. And it's an issue of public importance as demonstrated by the robust participation of amici in this case, not just on behalf of Mr. Ramon, where the law professor stated that Homeland Security has transformed interior civil immigration enforcement to target the entire immigrant population, but also on the side of Lincoln County, where the United States has weighed in, saying that these cooperative efforts are critical to enable the federal government to identify and remove the hundreds of thousands of people who violate immigration laws each year. It's an issue of public concern because it impacts our frontline lawyers, the public defenders, who but for the immigration detainer would be able to meet with their clients who are subject to the detainers in the comfort of their own offices or in their home, but instead are forced to meet with them in a holding cell in a local jail. And finally, it's an issue of public importance because of the fundamental interest that is at stake here, which is a liberty interest. Now, on the second point, which is the desirability for an authoritative determination to guide public officials in the performance of their duties. On this point, the county didn't even respond, and I suspect that the reason that the county didn't respond is because it is in their interest for an authoritative determination for this court to reach the merits and to tell Lincoln County, to tell Gallatin County and Yellowstone County and all the counties that are honoring immigration detainers on this day, whether or not there is arrest authority to so hold those individuals. These are novel legal questions that we're addressing here today. Is it an arrest? Is it a rearrest? Is local law enforcement required to comply with immigration detainers? And what happens if they do or don't? And the reality is that these public officials are operating in a sphere where they don't know whether they may, in fact, be subject to civil liability and money damages, as we see in the Roy v. City of Los Angeles case. And then finally, the likelihood that this case will recur. Obviously, this is not the first time that a similar fact pattern has come before this court. In 2017, the Valerio Gonzalez case came up on a habeas petition. There's a third case that's pending in Gallatin County, the Soto Lopez case, which Judge Holly Brown has stayed pending the outcome of the instant action because she recognized that what this court does with this case will gravely impact the Soto Lopez case. It's likely to recur because we've seen 135 detainers issued across the state of Montana in 2017 and 18. We don't have the data for 2019, but all indications are that that trend is pointing upward. And finally, it's likely to recur because the sheriff admits that it's his practice to comply with immigration detainers. So this case maps particularly well onto the public interest exception. I'm not going to go into detail on the capable of repetition exception, except to say that these exceptions are developed for different sets of fact patterns. And the reality is that the focus of the capable of repetition doctrine, which is on whether or not the challenged action is too short in duration to be litigated prior to cessation, that this is the unique case for which two exceptions to the mootness doctrine apply. If the court looks at the Walker case and the Weir case and the involuntary commitment cases, you see that there's a very clear analogy between those short duration cases and what we're dealing with here today. So again, the facts of this case map particularly well onto these narrowly circumscribed exceptions to the mootness doctrine. It's well within this court's discretion to reach the merits, and unless the court has any further questions, I'll turn it over to Mr. Galindo to argue the merits. Thank you.
Thank you, Mr. Ray. Mr. Galindo.
Thank you, and may it please the court. In chapter after chapter of the Montana Code, the legislature has set out arrest powers for state officers. It has done so for criminal arrests, for arrests with a warrant and without. It has has done so for a limited number of civil arrests. It has said when state officers can make federal arrests and when federal officers can make state arrests. Nowhere in this thoughtful framework has the legislature granted a power to state officers to arrest for civil immigration matters. For that reason, the court should confirm what the legislature has made clear. There is no power for the jail to arrest someone named in a civil detainer request. Now, just as a roadmap, the basic points of our argument, first are that this requires state law authority. Second, that this is an arrest. And then third, that there is no such arrest authority in statute or in the common law that applies. So to start with what I hope is a brief but fundamental point, and one that I take to be undisputed, and that is that you must have state law authority for state officers in this circumstance. That premise is foundational to state sovereignty, to the ability to govern one's state's officers. And it's a line of cases that we cite in our briefs and that I don't take to be disputed. Cases include DeRay and Miller. So as to arrest, which Mr. Raitt covered briefly in response to Justice Wright's question, it is an arrest to hold someone for a new reason when they would otherwise be released. Courts resolving this question in the context of this case have all agreed with Mr. Ramon. The United States and the sheriff cannot cite a case to the contrary and do not cite a case to the contrary. Montana law is also clear on that point. So the Norvell case that we highlight in our papers in the opening and in the reply, a person already in custody was arrested, the court held, when new paperwork extended his detention beyond the point at which he would otherwise be released. The Holloman case also recognizes that you can be arrested while already in custody, and the governor's warrant framework also recognizes that point as well, particularly the habeas corpus provision at section 217, which recognizes that you can challenge your arrest on the governor's warrant before the requisitioning state comes and gets you. So the state that seeks you doesn't need to come and pick you up for you to be able to challenge the arrest on the governor's warrant. You're already arrested at the point that that warrant has been asserted against you and is holding you in custody.
Counsel, what's the significance of placing it in the context of whether it's a re-arrest, a continuation of an arrest? I mean, we have Fourth Amendment considerations when we make a stop and the purpose of the stop ceases and the person can no longer be held. So can you place it in the, why is it significant to place it in the context of whether it's a re-arrest or not?
So two reasons, Justice McKinnon, and I think you actually touched on both in your question. The first reason is conceptualizing it as an arrest means that you need a state arrest power that needs to be granted somewhere, otherwise you don't have the power to do it. The second point, which you gestured at in your question, is it's a well-recognized principle. We cited the Rodriguez Supreme Court case, but it's also very well recognized in Montana law that once your reason for stopping someone or for holding someone or for arresting someone has ended, to extend that detention requires a new justification, and it does sound in constitutional concerns, and it's reflected both in the tests that you all, that Justice Sandefur laid out in the Crochelle case in 2018, noting that even a short detention raises constitutional concerns and has to be justified, and it's also present, and I will keep making this point, in statutes, because Montana codifies its arrest powers. And so in the investigatory stop statutes, Montana is very, very clear that once the reason for that stop has ended, the stop must end, right? And you need a justification to prolong it. So continued custody doesn't reflect what is actually happening because you are asserting a new reason to hold someone, and they would otherwise be released. And that is an arrest, and that's what sets you off on the path of where is this arrest authority granted. Mr. Raitt addressed where we think the arrest occurs, when the attempt to post bail happens and that is thwarted, and there's this reason why is asserting the detainer and that this person will not be released. That is the point at which Mr. Ramon is arrested. Cases recognizing that point, that thwarting someone's ability to post bail counts as an arrest, include Hernandez from the Second Circuit, and Miranda Olivares and Ochoa that we have cited. So I want to turn to the search for state law authority, and I think the appropriate place to start is the statute that the district court held granted that authority. That's Section 2203, and nothing in Section 2203, the jail statute, sets out any arrest powers because we know those powers are defined and provided elsewhere. This is basically an argument about the structure of where arrest powers are located. Other parts of the code provide powers to make arrests, often devoting entire chapters to defining and limiting that arrest power. They set that out typically in very plain language. You can arrest for the following reasons, in the following circumstances, in the following ways, and so forth. The next step in what happens after someone's arrested is typically that they are taken before a justice of the peace or a municipal court, or there is some form of judicial involvement. And that's the point at which so justices of the peace in their jurisdictional grant are called examining and committing courts. And the reason why is because that's where the initial arrest is tested in some limited way to see if it appears at that point to be proper, and if it is proper to commit that person to further detention, or say in the mental health context, to a hospital or other facility. So those two ideas, arrest and commitment, have already happened at the point at which you reach the next question, which is commitment to where, or where can that person be confined? And that's where the jail statute comes into play. The jail statute answers that question. It answers the broad category of who's allowed to be held in the jail. But it presumes that arrest has already happened and that commitment has already happened, and those processes and those powers are set out elsewhere. The language in 2203 and in the surrounding statutes about governing jails are consistent with this point. They talk about how detention centers are used for committed or sentenced people. In Section 2242, about who pays costs, it notes that a detention center is for the confinement of arrested persons, and there's similar language in Section 2201. And again, who pays the costs is the arresting agency, because the arrest has already happened and is already provided for in other statutes. We have a separate argument that we make in our papers talking about looking at the statute of 2203 itself, and even if you thought that statute granted any kind of arrest power, civil process, which is what the district court thought this was, is defined to require court involvement, judicial involvement. You don't need to reach that argument because arrest power is contained elsewhere and commitment power is contained elsewhere, and the jail statute has nothing to do with granting an arrest. But if you were to reach that point and examine what civil process means, it is quite clear and repeatedly defined in the statutes to require judicial involvement. And the same is true for a writ, which I believe the United States is trying to contend that that's what a detainer is. That also has to come from a court and also has to have judicial involvement. And detainers are never reviewed by a court, never involve a court. They are issued by an immigration officer. So once you conclude that the jail statute does not grant any kind of arrest power, and you go searching for anywhere else in the code where that arrest power is granted, there simply isn't a statute on point. We have canvassed those arrest powers and cited them in the opening brief at length. Montana defines its warrants. It generally requires judicial involvement. If there's an exception, such as in the initial arrest of someone for probation or parole, or certain other limited exceptions. They are crafted, they are noted, and they are defined, and the legislature has done so. I would note with the argument that this might be a warrant, even by its very terms, the Department of Homeland Security has something it calls an administrative warrant, and that is not issued in this case. So even if you were to contend that somehow any of the documents in this case are a warrant, even DHS doesn't consider its detainer to be a warrant. It doesn't call it a warrant, and it has a document that it calls an administrative warrant and hasn't been issued in this matter.
Well, the document that they did use is voluntary, right? The terms used in the document don't reflect a warrant, correct?
That's exactly right. That's exactly right. And I think it is undisputed that this is a voluntary request. So to fulfill that request, you must have an arrest power to do so. Nobody is purporting to say it's a command that this person must be held.
Mr. Galindo, do you know if these administrative detainers are used within the federal system, such as with the person who's being held in a federal institution and otherwise would be released? And if so, what the process, how they're recognized there?
So it depends on, so Justice Baker, it depends on which agency is carrying out the arrest. So if it's ICE, typically what they do is they use both documents. They use the detainer and also an administrative warrant. Even federal officers are actually limited in their ability to make a warrantless arrest for a violation of a civil immigration law. There needs to be a reason to believe that the person would escape before a warrant could be issued and the administrative warrant could be issued. So as I understand it, the administrative warrant is an attempt to resolve the issue of, do you have a warrant for this person such that you can go ahead and arrest them and you don't need to show that they might otherwise escape. That's the issue that the administrative warrant is typically trying to fix.
What's the process for the administrative warrant to be obtained? Because it's just from the Attorney General by the statute, not a court.
That's right. In terms of obtaining it, it's not meaningfully different from obtaining the detainer. It's usually the same immigration officer signing just a different document that says this is an administrative warrant. It has very similar information in terms of a checkbox saying this is the general reason that we're going to arrest this person.
So, and maybe this question might better be directed towards the county, but so then I'm curious as to how the authorization for the detainer that's found at 8 CFR 287.7, it invokes the authority of, it says they're issued pursuant to 236 and 287 of the Act. And I'm curious because that's the first line, as we were just talking about, of 236 reflects the arrest and detention pursuant to a warrant. So, and that's where I guess I'm trying to connect the dots here between the CFR and what is ostensibly the authorizing statutes.
So, only in the regulations is there anything referring to an ability to hold someone. It's not in the statutes itself. The amicus brief of the immigration law professors and practitioners addresses this particular point, essentially saying this is not something, a process that's even authorized under federal statutes themselves. So it's not really raised in this case. I don't think that issue, but that's, I think you're right to perceive that disconnect and perceive that may be an issue, but in terms of state law authority to hold someone, that argument is entirely grounded in Montana laws and Montana code.
Well, and this, I guess, to connect the final dot, I mean, that's my question, because even if we assume for the sake of argument that 732.2203 sub 3 is the statute upon which the district court relied. That is basically, the district court relied upon the phrase "or other authority of law." And so I think whether this issue is directly implicated, would seem to me that it's at least indirectly implicated, but if we're going to say "or other authority of law," you have to connect the dots to where that authority of law comes from. And if the statutes don't authorize the CFR that provided the basis for the detainer, then where does the other authority of law, where is it?
So, Justice Shea, I think that's entirely right. And I just want to clarify, though, that we are not necessarily asking this court to do federal statutory interpretation, because even if there was that authorization in the federal statutes, you still need a state law arrest power for the state officer to carry it out. So I agree that that is a large issue in terms of the federal framework, but you're still asking a state officer to hold someone, and that requires a state arrest power. That requires something that triggers into action the other authority of law, and there simply is no such power. I agree with you, neither in federal statute or in state law, but in terms of the claims we're making in this case, they're fairly narrow. It's about state law and only state law because the state officer needs that power.
Well, let me ask you a similar question. Assuming for sake of discussion that federal law or the federal government has preempted the field as to education, immigration, would CFR even be sufficient to require a county sheriff to detain somebody?
It's hard to see how
as you mentioned, there's no federal statute on it, so it's a federal reg. And my question is more along the lines, perhaps, of the 10th Amendment argument, is what would give the federal administrative process and executive branch regulation the authority to order a county sheriff to do anything?
So, Chief Justice, I think that's correct, that you would sort of be, it would be an even larger 10th Amendment concern, because it would not just be appealing to whether Congress could pass a law to command state officers to do something, which raises important commandeering concerns. It would be rather through a regulation that can occur. And I think that's an even more extreme example of a problem that would be raised in that circumstance. Not, I don't think, presented in this case, but...
Well, again, if you're interpreting under authority, other authority law, it seems to me it could be raised.
Yes. No. I think if you think that 2203 could possibly grant an arrest power and it could possibly be under authority of law, then I think, yes, it would become relevant. So I want to quickly touch on the absence of common law. I think that's important to reach because when Montana courts decide if there's an arrest authority, what they consistently do is look to the statutes and only to the statutes. Whether that's in Bradford or Lemon or Upgraph, they never look at common law to find an arrest power. Bradford says, in that case, the power to make a warrantless arrest, if it existed by statute and statute alone, and it cites the predecessor statute to the modern warrantless arrest statute. Just like many of Montana's arrest statutes, it's been on the books since territorial days, so the existence of statutes to govern arrest in Montana is just thoroughly and clearly established, and when they're updated by the legislature in narrow and careful ways. Seeing no questions at this time, I might hold my remainder of time for rebuttal.
That's fine. Thank you, Mr. Doe. Ms. Lennon.
Chief Justice, Associate Justices, may it please the Court, My name is Maureen Lennon, and I am with the Montana Association of Counties. We represent Darren Short in this matter. With me is Francesca Genova. She is from the United States Department of Justice, and she will be, she's the amicus for the United States, and she will be addressing the arrest issues just addressed by the prior counsel who spoke. I will touch on the argument that we do not believe that he was arrested. We do not believe that he was ever eligible for release under the facts of this case. But other than that, I'll address the mootness doctrine. I have 20 minutes for my argument. If I do not take that, I would ask the court to allow Ms. Jennifer.
You get 30 minutes no matter what.
Thank you. Thank you, Chief Justice. I think we've heard and we know that this case is not fashioning a remedy for Mr. Ramon at this point. Mr. Ramon has been sentenced, he's been deported, and he's no longer, the preliminary injunction TRO will no longer apply. We're here today we're here today to have an advisory opinion issued on the policy and practice of Montana sheriffs. We know of two apparently in Gallatin County and Lincoln County to cooperate with federal detainer requests. And I'd like to, I believe the background is undisputed as well, but I'd like to remind the court that Mr. Ramon was in Lincoln County. He committed a felony burglary. He ended up in jail. And the sheriff at the time, Robbie Bowe, received a detainer request. That request was never acted upon. Mr. Ramon's wife hired a bondsman, and Judge Cuff referenced this in his order, and the bond was never posted or it was withdrawn. We're not sure. But Judge Cuff said in his order.
Counsel, what else could be done to make the issue ripe for this court to consider? Or are you saying this never should be considered in any kind?
Well, for example, if Mr. Ramon were concerned about his bond being affected or his bail being denied, he could have filed a writ of habeas corpus. He could have taken some other action.
So, counsel, a writ of habeas corpus means that there's an illegal detention.
Well, what I'm saying is he could have gotten it in front of the court. And that's what they're saying. That's what they're saying today, is there's an illegal detention. That's what we're being told. The minute, in every brief, including amicus, there is an assumption, and Mr. Raitt just said it. The minute that bondsman talked to somebody, and in one of the amicus briefs it said the instant that he indicated his intent to post bond, he was entitled, he was unarrested basically, he was entitled to release, and that's what started the new detention.
I think what he said was that the moment when the posting of bond became thwarted by this detainer would be when the case becomes ripe. And my understanding of what we know from the record is that they decided not to post the bond because it would end up being futile. So what Mr. Raitt's argument is that the county is suggesting that it instantly goes from futility to mootness.
No, that's not what we're suggesting.
So that's what I think we're asking you to.
Justice Baker, what I'm saying is, and this is what Judge Cuff actually said in his order. After, as Justice Nelson pointed out, he said that there were no facts established. But here's what we're going to assume for purposes of dealing with this. That Mr. Ramon argues that he is unable to post bond because defendant will honor the immigration detainer and hold him until a Border Patrol officer takes him into custody. Neither party disputes that in the event bond is posted, defendant will advise immigration officials and, if necessary, hold him until the immigration officials pick up the plaintiff.
So are you saying he had to actually go, it went down, he says, I'm ready to post bond, the bondsman's there with the money. They say, well, if we take your money, we're not letting him out anyway. That he should have posted the bond, forfeited the unrefundable fee, and that's the semantic thing we're playing with here of whether or not he was eligible to be released or not?
It's not a magic thing, it is conjecture. The Border Patrol may not have come to get him. The Border Patrol may have been there
But even
before
if they didn't come to get him, if he posted that bond, right, he'd have been eligible to leave, but nobody would have let him leave.
He would
Because
not,
they told him he wasn't gonna let him leave even if he posted that bond.
they didn't tell him, they told the bondsman.
Oh,
But-
okay.
But what I'm saying is, you're not eligible to leave jail the minute you hold out the money. There has to be processing. It is conjecture to assume that it is conjecture. It may have happened. If the Border Patrol wasn't there by the time he was processed out, or at the time, quickly, because it's Libya and Eureka are fairly close. And as former Sheriff Bowe said in his affidavit, he's never had to hold anybody for very long. But the law is pretty clear that you don't walk out of court when bond is posted or walk out of the detention center. You get to process somebody out. And so what I'm saying is, I think it's dangerous to make these assumptions and to make a ruling that when someone is trying to post bond, because there's a cooperation, a practice of cooperating with a federal detention retainer, that the minute that noise is made, or the minute a bondsman says, I'm going to post bond, well, I just want to let you know that the practice is to cooperate with the detainer. The bondsman says, no, not going to post bond. That's the moment that he was eligible and free to leave. And that's what we have to say, that he was free to go. There's a court order. He's in detention based on a court order, based on a felony arrest. And so...
But counsel, the county is telling the bondsman that it's futile to post bond.
That's how the bondsman,
How else would you interpret what the intent of the statement from the county to the bondsman was?
I'm not saying, that was informational. It was informational for the bondsman. What I'm saying is, at this point, it is conjecture, and what the ACLU and Mr. Ramon is asking this court to do, is make a ruling that this is a new arrest, a new detention. This is a continued detention. The condition precedent to release was not satisfied. If he'd posted the bond and he'd been held, he may have an argument. But I don't know that, and you don't know that, because we don't know what would have happened. Even Judge Cuff said in his order, we don't know what would have happened, if necessary.
Well, but we have to take the sheriff at his word, which was that he was going to honor the request.
If
And it wasn't for an indeterminate time, it was for 48 hours.
If necessary. If necessary. What I'm saying is, by the time he was processed out, the Border Patrol could have been there. The Border Patrol may have been there immediately upon posting of bond, because that conversation takes place between the detention center and the bondsman, and potentially the Border Patrol. So even Judge Cuff recognized, if necessary, it's still conjecture at this point.
So if the court disagrees with you on that point, how would you address the mootness exceptions?
Yes, and I will address the mootness exceptions. Thank you very much. First of all, I would like to say, as a matter of policy, Montana has a long history of cooperating with other law enforcement agencies. We have a mutual aid statute. We have very rural communities where, if the only deputy on duty in the middle of the night in Sheridan County has to make an arrest and needs help, he calls on the Border Patrol. We have, because of the way we live and because of our state, it's rural, it's big, and there aren't a lot of people. The mutual assistance of these law enforcement agencies as a policy is very important. And sheriffs should have the authority to cooperate in this way if they like. But in terms of the mootness exceptions, they are exceptions, first of all. We need to remember they are exceptions to the rule. And the first mootness exception is that it is a matter of public importance. The ACLU and Mr. Ramon point out that there are 135 detainer requests in 2017 and 2018. This number is not in the record, but taking him at his word and his research at its word, this is meaningless. A detainer request doesn't mean anyone was detained. It means that the Border Patrol sent a request.
Ms. Lennon, you're telling us before we even get to Mr. Rait's assertion of public interest here, that as we start out in this discussion, that it's of significant and compelling importance to the sheriffs to cooperate with the federal authorities in this and other regards. So how is that not rise to the level of being of public importance?
It is simply done. It is a practice
Is it
in
important or is it
Montana.
not important, as you assert, for sheriffs to cooperate with federal authorities in this regard?
It's important to have mutual cooperation, and I think it is important for them to do that.
Then how can we say there's no public importance to this issue, whichever side we think the gavel should drop?
The importance in terms of masses, we don't know that it is we don't know as we sit here with this record, and my point is, we know of 2 counties. We know of 2. We have to rely on the record. There's no record that more than 2 of the 56 counties. It's important to have cooperation, but we know of 2 of 56 counties in Montana on this record that have a.
Let me ask you another question, a little bit different, but I want to know if Lincoln County has a contract with the Border Patrol.
I don't believe so.
Formal mutual aid.
Well,
agreement.
The mutual aid statute, I think, refers to law enforcement, to penal issues. That was an example of the cooperation. I'm not aware that, I don't think this would fall technically under the mutual aid statute. I refer to it as one of the
So
practices
there's
in
no
Montana.
contract here?
No, I don't believe there's a contract. I believe there's a practice. Yes.
Running out of your,
Pardon me?
you're running over your 10 minutes.
Oh, I had 20, but, okay. I didn't think I would take it, but in any event, we know of 2 of 56 counties, that's what we know of. And we know of 135 requests. We don't know how many detainers, or how many issues, except there are apparently 3. So volume alone, based on this record, would not dictate that the court, or militate that the court make an exception to the.
Counsel, this court protects the rights of individuals.
Yes.
And one individual who's detained or whose freedom is deprived is significant for this court to take interest in and is a public interest in itself. So when you talk about volume, I mean, we're in the business of protecting one person's rights. And when that person is detained unlawfully, that's of public importance. Can you address that argument?
I'm not suggesting that one person's rights that a person's rights are not important. I'm not suggesting that at all. I'm talking about for an exception to, whether this case is moot, his rights are no longer affected. We're not talking about his rights anymore. We're talking about a change in a practice, calling into question a policy and practice of the Lincoln County Sheriff's Office, which is apparently going to provide guidance to Gallatin County. This is not about Mr. Ramon anymore. That issue is gone. He is deported. This is about, is this a significant public concern at this point, on this record? Otherwise, it's simply an advisory opinion, and that's what you're being asked to give, is an advisory opinion, and that's the reason for the mootness, the exceptions to the mootness doctrine. Again, they're exceptions. Otherwise, I don't think it's any secret that this is a whistle stop along the way. The ACLU is going from state to state to get state courts, based on state law, to find these immigration detainers unlawful under state law. You have to look at, in my opinion, and obviously that doesn't count as much as your opinion, or even close, you have to look at this case and this record to decide whether this is the case. This is the case. Otherwise, you are giving a strictly advisory opinion on this policy and practice.
Well, Ms. Lennon, coming back to the question that Justice McKinnon asked you, and I think that Justice Gustafson followed up on, in your estimation then, what does it take for this issue to become ripe for review by this court?
What does it take for this issue to become ripe?
Yes. You say it's not about Mr. Ramon, it's about something else, so what does it take for that issue to become ripe before this court? Because you're telling this is not it.
In this record, this is not it.
So I'm asking you, what does it take for this issue to become?
Well, I suppose it takes this court to find, if the court is going to find that this is an unlawful arrest, that is when I would just say, if this court finds that he was rearrested based on these facts, then that's a decision that the court can make.
Well, if he was actually held, let's say he posted bond, and he was held for 48 hours, would you agree that was right?
Yes. Yes, and then then the court would have to decide whether the court is being asked to decide whether the detainer is lawful, whether the sheriff has the authority to do this. Pardon me? It would not be conjecture at that point, but then the court moves to the mootness doctrine. Is it a moot issue? And that's what we're talking about now, is just the exceptions to the mootness doctrine. And the second, I don't want to take up all of Francesca's time. Clearly, the second exception is that this has to, in almost all cases, except cases involving where you need to protect the plaintiff, it has to be a risk to the plaintiff again, the same plaintiff. So, and that's not there's no argument that that's not the case here.
Ms. Lennon, before we hear from the United States, I wanted to ask you directly in regard to Section 732, 2203, sub 3. What specifically is the other authority of law upon which the county relies to hold someone like Mr. Ramon on these detainer requests after the state law authority for continuing to hold him dissipates?
If the state law authority dissipates, the other authority of law, I can't get into the legislature's mind, but I do know that people are held, and as Judge Cuff held, and we're talking about Judge Cuff's ruling on the order, on the preliminary injunction, was that you can detain someone on a civil process. Judge Cuff is talking about detention, not arrest, continued detention. And I don't know what the legislature was talking about when it was other authority.
But I'm asking you because this is not process as defined by Montana statute. So the other authorization here under this statute that we're talking about is that the county can continue to confine these people under, quote, other authority of law, end quote. So to the extent then that the sheriff is going to cooperate and honor these detainer requests from immigration, what is the other authority of law upon which the sheriff is acting to continue to hold these people?
And I'm sorry, Justice Sandiford, you got that quote from the statute?
Yes.
Okay. That is not what we argued. I did not argue that statute in my brief.
Okay, so let me ask you this before you hand it off here. What authority, aside from this practice and this interest in cooperating with federal authorities, which I understand, but what legal authority is the county standing on to say, we can continue to hold these people pursuant to this detainer request after the state law authority for continuing to incarcerate them disappears?
This authority that the sheriff has to keep the peace, I'm not arguing that there is authority to rearrest somebody. I'm not arguing that at all. I mean, we don't have probable cause. Pardon me?
What authority is there to continue to hold them after the state law authority goes away?
If it goes away, it's reasonable, the federal law, there's even federal law, it's reasonable to hold somebody in a detention facility for processing out, for warrants and holds and warrants. There are many reasons to hold somebody. This is simply a voluntary, there's no statute that says, although the legislature could remedy that, there's no statute that says you get to hold these people on immigration detainers for the federal government. There's no statute like that.
Okay.
And okay. So.
Thank you.
Thank you.
Chief Justice and the Associate Justices, may it please the Court. My name is Francesca Genova, and I represent the United States as amicus in support of the Sheriff in this matter. If this Court reaches the merits, it should uphold the Sheriff's cooperation with immigration detainers. Immigration detainers are a lawful exercise of the United States' sovereign authority over immigration, over which it has plenary authority, and federal courts routinely recognize that immigration detainers are lawful under federal law. Because they are lawful under federal law, Montana law must recognize that lawfulness under federal law in interpreting its own state law.
What Montana law, though? I mean, this is kind of picking up on what Ms. Lennon's response was. She said there's no statutory authority for it. So what Montana law authorizes, whether we call it a new arrest or the continued detention of an individual pursuant to the federal request?
So the distinction between a new arrest and a continued detention is one that we would say ultimately comes to the same conclusion. But in terms of, they're two different analyses. So under the continued detention analysis, cases in the Ninth Circuit have routinely held that a continued detention to check for wants and holds is a lawful temporary extension of custody pursuant to the prior arrest. And of course, if you are able to check for wants and holds, you must be able to detain a person temporarily to actually achieve the hold, because then what is checking for want and hold for? In terms of that temporary detention, it's supported by the probable cause determination of the immigration detainer. The state, in comity and with a look towards the federal sovereign, can accept the immigration detainer's probable cause determination under the collective knowledge doctrine, which this court has acknowledged in State v. Williams. Under the collective knowledge doctrine, that probable cause attribution of the federal government is attributed to that temporary extension of the hold.
Counsel, where's the probable cause for a criminal offense?
It is not probable cause for a criminal offense, but there's no requirement that probable cause be for a criminal offense. Not in federal law, which the immigration detainer is for.
Isn't the Fourth Amendment federal law?
The Fourth Amendment is federal law, and it says that probable cause is available with immigration detainers and immigration enforcement under the plenary authority of the government. There is the vast majority of federal cases, with like one outlier outstanding, has recognized under the Fourth Amendment that detainers supply the proper probable cause. In fact, Morales v. Chadbourne, the First Amendment case or the First Circuit case on which plaintiffs rely, acknowledged that the detainers do provide that probable cause. There's McLean v. Crabtree out of the Ninth Circuit, which is the jurisdiction that Montana is in, that also recognizes the validity of detainers. So the federal system recognizes this civil probable cause for civil immigration enforcement.
So I just want to make sure I understand your position then. So I'm not questioning the validity of the detainer itself, but then it's a request, and we're sovereign, and so what I'm asking is what is there in Montana? I mean, the position of Mr. Ramon is that there has to be some authority for the arrest or the detention in Montana law. So where is the Montana law authority?
So there are 2 points on that. First off, Montana law is explicit in statute that the common law continues to exist even if statutes are codified, so long as they're not in conflict. Now, in Anala v. McLeod out of this court, this court has recognized that the duties of the sheriff remain what they were at common law.
Here's the conflict. Here's the rub. So our definition of a detention center says that it applies for the purpose of confining arrested persons. All through our detention center statutes, the term arrest is used. It does acknowledge that we could hold somebody in one of the state detention facilities, but it also requires an arrest. So you're arguing there was no arrest. So now we have a situation where we have black and white law from the state of Montana, and we have some kind of an amorphous law or from the federal government. saying that we're required to, sheriff is required to not follow state law?
It is not that the sheriff is required to not follow state law. We maintain that the state law states that detention centers are for the detention of arrested persons. Mr. Ramon was arrested. He was under the state custody. There wasn't even in this case a brief temporary detention. He was never held under the detainer for any amount of time. However, the sheriff in his affidavit at the district court stated that detention was no longer than 1 to 2 hours in the normal course of business. So that's the normal length of time for wants and holds. So he was detained under his state arrest. Now the probable cause determination changes. So once he is held under the detainer, that's ICE's probable cause, or DHS's. This isn't an ICE detainer. However, a new seizure is not the same thing as a new arrest under the Fourth Amendment. The probable cause determination does not need to be related to the actual term arrest. And under Montana law, the arrest statute describes the taking of a person into custody. It does not talk about the continued detention. So there needs to be a separation out of the new seizure probable cause determination from the statutory definition of arrest in Montana law, which involves, as in the cases that the plaintiff cites, involves incidents where a person is seized from being free on the street. Mr. Ramon was not free. He was detained pursuant to his criminal charge.
Well, how do you distinguish that from what we held in Norvell, though, where we did characterize, I guess I'm just asking you, what's the distinction here where in Norvell, he was on a hold for a PV, that expired, he's still in detention, and then he is charged on the same day with the arrest warrant for the new criminal charges, and what we held was that the expiration of the probationary hold with the absence of every probationary proceeding was not, or was, valid or not, effectively an arrest related to the new charges. I'm just trying to draw the distinction there. Norvell never left custody. He was in custody on the PV. That expired. We held that was effectively an arrest when he was then continued to be held on the new charges.
So Norvell involves the determination of, I think it was length of time before he appeared or she appeared before a judge. The court, colloquially uses the term arrest to mean a new seizure in that case. The court does not use any of the arrest statutes to analyze. In fact, in that case, the warrant was or the new detention authority was, I'm pretty sure, served by the probation officer, which there's no analysis about whether a probation officer has the authority to do that. So the fact that the court used the word arrest here is not talking about the technical statutory structure. Now, Montana law has a number of arrest statutes, but those arrest statutes include for a laundry list of different types of things, including civil arrests. So to the extent that the argument is that, the government system is the federal government system is a civil system, Montana law recognizes the authority to arrest under civil conditions. And importantly here, because this is the system that Congress has created, a civil immigration system, this court's definition of arrest and understanding of magistrates and writs and whatnot needs to be understood to recognize the validity of the United States' sovereignty over immigration and the validity of its own writs. Importantly, the arrest statutes in Montana states that unless the context is otherwise, this is how things are defined. The context here is, of course, different because you're dealing with the federal sovereign. Additionally, the sheriff has the duty to preserve the peace and serve all process under 732-2121, which incorporates that common law. I see that I'm out of time. If there's no further questions. Thank you.
Thank you. And at the risk of playing whack-a-mole, I know that the county spent the majority of their time addressing justiciability, so let me address some of those arguments on rebuttal before again turning it over to Mr. Galindo to respond to the United States. Under the county's argument, every case involving the issuance of an immigration detainer will be either ripe or not ripe or moot before this court has the opportunity to review it. And I think that the practical reality is that if you look at every other detainer challenge, both in Montana and elsewhere, those cases came up on a procedural posture where the case was moot because no effective injunctive relief could be issued for the precise reason that that individual was in federal custody. The county cites Judge Cuff's order suggesting that somehow this is a hypothetical case, but Judge Cuff roundly rejected the very same argument that was presented in the district court. And he said defendant's argument as to standing puts plaintiff in an untenable position. And where you have a situation such as this, where plaintiffs are repeatedly put in the untenable position, that is precisely the type of case for which an exception to the mootness doctrine should apply. Now, with regard, the county repeatedly suggests that somehow by reaching the merits, the court will be rendering an advisory opinion in this case. But if you look at the Montanans Against Assisted Suicide case versus Board of Medical Examiners, that case went into great detail talking about what is and what is not an advisory opinion. And in that situation, the appellants were asking this court, even though the matter was moot, to go ahead and override or overrule the Baxter case. But the court said that going that length would be advisory. It would be an opinion on the merits of a decision without the benefit of concrete facts or adversarial development of arguments. This case has been developed with capable opposing counsel from the get-go, where the arguments have been fully presented to the court, and we have a ruling on the merits of the claim that Mr. Ramon was unlawfully held. It's not advisory as well because we're talking about real people here. We're talking about Mr. Ramon, and we're talking about the necessity of guiding public officials in the performance of their duties, who, in the performance of their duties, are detaining folks across the state as a result of the federal immigration detainers. And then finally, Justice McGrath, you had asked about whether or not, in fact, this case would ripen had he posted bond. So imagine the world in which Mr. Ramon had paid the bondsman and posted bond, and I believe, Justice Sandefur, you also touched on this as well. In that situation, we would have had 48 hours or less to get in front of a judge before he's in federal custody. And again, in that situation, it would be virtually impossible for even a district court to review, much less have appellate review to afford Mr. Ramon effective relief. So unless the court has any further questions on the mootness.
I have a question, Mr. Raitt. So you had, and I posed this, I think, well, touching on Ms. Genova's statement. So for purposes of what's before us today, you're not challenging the validity of the detainer itself. It's the execution of the detainer by the sheriff and whether there is Montana law to support that. Correct?
Correct.
So if the detainer itself is valid, and for our purposes of this discussion it is, then what about Ms. Genova's comment that just under generically the common law, the rights of a sheriff to honor what is an otherwise valid request to hold somebody by another sovereign?
Well, this again turns on the issue of is it an arrest, right? Because the reality is that if this court deems that indeed Mr. Ramon was rearrested, which is to say that there was a new purpose for his detention pursuant to the federal immigration detainer, then there must be state law authority to support that rearrest. So can DHS, ICE, CBP issue immigration detainers? Of course. But the question before this court is whether local law enforcement has arrest authority to hold somebody for a new purpose. And that new purpose ripens at the moment that the person is is eligible to be released on bail. Like any other person in this situation, Judge Cuff determined that Mr. Ramon could be released once he posted bail. And any other person who's not subject to a detainer could do just that and be free pending trial and be presumed innocent. But in this situation, once he's being held on that new purpose, which is the immigration detainer, there must be state arrest authority.
But he could be held, I mean, let's assume that I don't remember whether it was Ms. Leonard or Ms. Genova, he could have been held, I mean, ICE or Customs and Border Patrol, whoever it was, picked him up when he ultimately did. He was there to be arrested by them, is that right?
You mean upon
his release,
sentencing?
After he was sentenced, or actually, I think the chronology was he was actually picked up before his sentence was imposed, wasn't it? But
Yeah, the chronology. So I think that goes to this issue that record is not before the court currently. So what's before the court is what is the record as it existed at the time for the motion that the preliminary injunction was argued and issued. So I don't think, again, whether or not there is a shorter period of time for which he was held pursuant to the immigration detainer or the full 48 hours, this court has held that even a short period of detention justifies or requires rearrest authority. And I believe Mr. Galindo will get to this in a moment, but the reality that, or this argument that that there's a time period that's required for booking or processing or that kind of thing, that's not a new purpose for which that person is being held. The new purpose is the issuance of the immigration detainer. Thank you.
So let me pick up on the processing or the wants and holds argument, because I think it's important to understand why that's not at issue in this case and why that's not relevant to this case. A detainer asks for detention at the point at which someone would be released, would otherwise be released. The point is, any processing that anybody has to go through to be released has already occurred. Once you reach the moment that they would be released and they are held, that's the point at which the detainer is taking effect on the person's liberty. You can see this from reading the detainer. By its very request, it says, when the person would otherwise be released, then hold the person. It then also disclaims having an effect on any number of things having to do with the jail, including custody classifications and including specifically release. So the detainer, by its very terms, is denying that it has any kind of effect on processing or the regular release of someone from jail. Mr. Ramon is not attacking the idea that there might be certain processes that any jail has to do before it releases someone. That's not at issue in this case. It's once he or anyone else would be released from the jail and he is held on the basis of the claimed authority of the detainer, that's the point at which the detention has to be justified. And it is not, like in these wants and processing cases, it is not that the jail, just through sort of inaction or administrative processing, is still hanging on to the person. It's because the jail says intentionally, we can do this and we are doing this. And that's why the conceptualization between arrest or just continued detention is important, because an arrest is a deliberate assertion of authority to hold someone, and that requires a particular justification. And so properly understanding the framework is important to understand why there needs to be state law authority in this circumstance. I would also note the sheriff in his brief on page 9 admits that detainers are not a usual part of release processing. So even the sheriff is disclaiming this idea of wants and holds processing and the detainer being involved. You also know that the detainer is not an unknown want or hold in the world that you are checking for. It is issued when the person, in this case, when the person is arrested. So it's not searching for, is there some want or hold that has suddenly dropped and you're looking to become aware of it. It's there the entire time.
So before you run out of time, I think it's important to address the government's argument that this is not a new arrest because it's a temporary extension of the original arrest authority, the reason that he was held under state law, and that not every seizure amounts to an arrest. Can you address that, please?
It's hard to see a daylight between whether someone is seized and whether someone is arrested. I mean, the Fourth Amendment law on seizure sets a baseline for what counts as an arrest, and you don't see arrest definitions change or or very much from state to state. And in part, that's because the Fourth Amendment sets this floor of this counts as a seizure. And if you were going to define an arrest to not encompass the seizure, I think you would be.
Well, we do that all the time. We do that all the time in Fourth Amendment analysis. The Fourth Amendment applies to unlawful search or seizures.
Yes, but in terms of whether or not something is in fact an arrest, it's hard to see how those two are not closely intertwined, whether someone is free to leave, whether an objective person would feel free to leave, whether you are asserting authority to hold someone, the formulations in Ellington or in Thornton in this court's case law.
Well, but even using Chief Justice McGrath's analogy, like in Fourth Amendment analysis, I mean, this is a circumstance where we don't, even when we're looking at, whether there was an unlawful, whether the seizure extended beyond what was necessary for those purposes, we don't refer to it as a rearrest once it extended. I mean, there was an arrest, there was they maintained custody, they detained, or whatever, the detention was extended. It's not like there's a continual rearrest at every moment after the person would be otherwise free to leave.
That's correct, but whether there is an assertion of a new reason to hold someone, right, as in Norvell, that is an arrest, right? And this court correctly recognized in Norvell that that was an arrest, and it didn't require that Mr. Norvell be temporarily released and then grabbed again, and it didn't characterize it as a continuation of detention, continuation of custody, even though the exact same officer was serving additional paperwork to continue to hold the person, right? So I think if I can just finish.
Go ahead.
If there are ancillary matters that would extend why you're holding someone based on the initial seizure, that may be permissible in some circumstances, and that may require what is the proper Fourth Amendment scope of that initial seizure. But if you are deliberately saying, this is a new reason for us to hold someone and we are asserting it against this person and keeping them when the reason for the previous detention has ended, that's an arrest. And that requires arrest authority. It does not require rewriting Montana law, which is quite clear that there is no arrest authority.
Thank you very much. Thank you to all counsel. This concludes the argument in this matter. The court will take it under advisement and will issue an opinion in due course.